All right. Good afternoon, everyone. Thank you for attending today's session of the Wednesday coffee break session. Today, we are going to be talking with Mike Burshak, who is an intellectual property attorney here at Foster Swift, who specializes in patent, trademark, strategy, acquisition, and general IP and business consulting work. Mike works with companies of all different sizes and as actually is a teacher, if I recall correctly, and teaches us new lawyers about all things intellectual property for two different law schools. So that's a really interesting area and a really interesting background that he has here. So today we're going to be talking about trademarks and giving you a little bit of a background on how trademark works, what protections can be offered, and why it's important to you. Today's host, I'm Robert Hammer. I am a corporate and real estate attorney in the Southfield office, and I can assure you that in my practice, we deal with intellectual property things on a regular basis, whether it's a day-to-day item or when you're selling the company, you're trying to make sure that all the protections are there for the new buyer, or if you're acquiring a company, making sure that you've got everything that you need to know. So this is an incredibly important area to have your finger on the pulse of. So with that in mind, I'd like to just kind of jump right into it by asking, kind of what the obvious question is, right? What is intellectual property? What are the types of intellectual property, and where do trademarks kind of fall within that scheme, Mike?
Oh, thanks for having me, Robert. I just want to let you know how much I appreciate being at Foster Swift and being a part of today's session. This is something that comes up all the time. People call and they think they want a copyright, or they think they want to patent a name, or they're not sure exactly what they need to do for a trademark. Some people think that they need a trademark to even use their business name in the first place, which is not true. And so a lot of times there's a lot of handholding and I guess educating not only the clients but the public in general on what the differences are. So this is something I go over in every class I teach, whether I'm teaching trademark law at Michigan State or IP practice at Cooley Law School. I try to make it very clear that there's distinct differences under the giant umbrella that is intellectual property. And intellectual property typically in the past means patents, trademarks, copyrights, and then trade secrets. And some of them are easy to dispel. For patents are generally for inventions. So if you invent a new composition of matter or a new gadget or a new process for making something, that falls under the patent umbrella. So you can pursue a patent, which is a deal with the federal government. They issue patents for new and useful inventions, and you get a limited exclusive right to that invention, however that works. I do a lot of that in my practice. And trademarks are very different. Trademarks are focused on source identifiers. Some people think you need to obtain your trademark registration, which is almost always federal, even though there is a state side element to it. But most of it is federal trademark registration. And what does that mean? You can't trademark your invention. Trademarks are entirely restricted to names. So for example, in Rob's background, most of you can see the word Canon is on that copier. So the company that owns Canon, and it could be the Canon company, I'm not sure, I could look it up. They own the mark Canon, the word, and it's specifically for the goods, probably related to copy machines and other types of electronic products or office products. And so trademarks are what they refer to as source identifiers. So I don't walk into a 7-Eleven, which is a trademark for the 7-Eleven company, and ask for, can I get that brown beverage that tastes better than the other brown beverage that is carbonated and it has a lot of sugar and a lot of caffeine? I go in and I ask for a Coke. So part of the original trademark process was to improve on economic efficiencies. So when you and I can have that language of marks that are tied to source identifying. So what that efficiency is created by allowing the public, when customers walk into a place, they're not being fooled. When I want to order a Coke, I know it's going to cost $2. I know it's going to taste a certain way. It's going to have quality and characteristics that I'm familiar with from the goodwill that was established by the Coca-Cola company over hundreds of years. Well, a little over 100 years. And that if they didn't have the right to protect that mark, meaning if they didn't have the exclusive right to exclude others from being able to use it, I wouldn't know whether I was getting the real deal or something fake from a knockoff company. And so by protecting trademark registrations, you're cementing and giving certain rights from a federal registration point of view to a source of goods. So the thing that comes up all the time from a small business or medium-sized company or a larger company concerns is, do I need this trademark to protect my name? And the answer is, it depends. And that's always the lawyer answer. But in reality is you don't. There is a common law cause of action if you've established that you are the source of a name or a device or a symbol or a logo, right? All of those things are available to obtain trademark registration. The advantage of obtaining a trademark registration is, number one, relatively inexpensive. Patents can cost you $15,000, $20,000 from start to finish. Trademark often costs you anywhere from $1,000 to $3,000. And the great thing about trademarks, patents, for example, they expire 20 years from the date you file. And that requires maintenance fees along the way. Trademarks will last forever so long as you continue to use them. So there's certain things that you want to go over with your businesses. Number one, you don't have to get a trademark registration to start using the name. In fact, in order to file for a trademark under actual use, you have to show date of first use and that it's actually out there being used. And there's an advantage to using it, is that you can establish some level of first use and that you have a degree of fame or notoriety in the marketplace. So if you're out there using the name, that's often a good thing. The thing is about getting a trademark registration, it gives you more rights than just, running the Rob hot dog company out on the corner or the lemonade stand for several years and then trying to get a trademark registration. If you had a trademark registration, it's applied federally. It serves as a notice requirement. It can serve as an asset to your organization. And not only is it relatively inexpensive to obtain that registration, which is why all the big companies file tons of them, you have to do one renewal at the 5 to 6 year mark. But then your other renewals, which again are not that expensive, especially if your mark is being used in commerce, every 10 years. So you just have to pay and submit your statement of use that you're still using the mark every 10 years.
Got it. So one question that I often get, and maybe it's not a question, maybe it's just a misnomer, right? Is people always talk about, well, I need a copyright. What's the difference, just from a high level overview, between a trademark and a copyright?
Yeah, thanks for bringing that up, Rob. So I mentioned at first, there's this umbrella term for intellectual property. And if you think of it in terms, the way I like to think about it is real property or personal property, like my Yeti mug right here, personal property. Real property, as in the land we use, we get a deed, we register that deed with the county, right? So we know physically the limits of what you own, right? I have this house, I own my car, or my bank owns my car until I pay it off, whatever the rules are. Intellectual property is like this intangible asset, right? I have this idea, and that idea is an invention, and that's I can own that idea through a patent, right? It's a way of bridging that gap between what's intangible and what you can actually hold in front of you, or at least look up and then claim ownership from a legal standpoint. And the same thing goes for trademarks, for source identifiers. For copyrights are for works of authorship, or generally speaking, people think of it as art. So Taylor Swift writes a song, she writes lyrics, she puts it on, she records it. There's certain copyrights associated with that. And she's gone through the very smart and innovative way of re-recording a lot of her songs and labeling them as Taylor's version, which her fan base is so big and strong. She's had, probably success that we've never seen from a musical artist. So that's sort of where the copyright world falls in. Now, software companies or ad companies or marketing companies that are writing content, all of that stuff can be copyrighted. But for a trademark, you can't write a book and get a trademark on the book, right? Copyrights also have limits. They last 70 years past the life of the author. So the Happy Birthday song is technically still copyrighted, and I think it's owned by GE or some other company. Mickey Mouse was one of the copyrights, like the original Steamboat Willie, Mickey Mouse. That's an example of something where that's going to expire because Walt Disney, the owner of that copyright, died a long time ago. Whereas you can put music catalogs or books and all that kind of stuff. They're works of authorship that are captured in a tangible medium. So if I write a poem on the computer, that qualifies as a tangible medium. I own a copyright in that, whether I register that copyright or not.
Okay.
But they have nothing to do with source identifying. So again, McDonald's is a registered trademark, both as a word on its own and also as a logo and a whatever they decide to submit as their design logo, right? And that's for restaurant services. So the other thing about trademarks is they're tied to specific goods and services associated with that brand.
Okay.
So, and when you submit your trademark application, that's the thing you have to do. You can't just, for example, someone called me the other day and they said, hey, I want to trademark these catchphrases. Like for what? T-shirts, swag, those are different categories, right? Even food falls into 2 or possibly 3 categories if you consider wine and spirits a separate category from food. So if you look up at the trademark office, there's a whole list of goods and services that fall into these international classifications. And when we file for a trademark, the filing fee is specific for one class of goods only. And if you want multiple classes of goods, which companies do all the time, right? Like Clorox, for example, as a cleaning product, they may file in disinfectants, which is class 5 under pharmaceuticals. They may file for chemical compositions in class 1. They may file for a different category, class 3, which has a lot of cleaning products in it that are not necessarily just disinfectants. So that would require 3 different filing fees and going into 3 different categories. And when you submit your specimen of use, you have to show how you're using it in the world. You have to submit it for each of those classes. And that's, I mean, we're really getting into the weeds on the trademark specifics, but it's really important to know that if one of our clients is selling their construction company, that their name doesn't necessarily mean anything in the restaurant category or in the metals category or whatever. So there's a lot of information and guidance that trademark attorneys can provide to the clients in navigating those waters that can be a little rocky.
Sure. And that actually kind of segues to my next big question, which is what is the general process, right, to register a trademark, without getting into a law school lecture here?
Sure. I mean, the simplest answer is it's relatively simple. We prepare an application. You have to, the information we need from the clients is what is the word or combination of words or device or symbol or design logo they want to trademark. So that's where it gets into the weeds, where you call me and say, I want to trademark Rob Hammer hot dogs and lemonade. And I say, okay, well, are we going to file for your name, just the words? Are we going to file for your design logo? Are we going to do a knockout search to make sure you don't step on anyone else's toes, which is something really important we should mention. And then the next question is, are we going to file for lemonade? Are we going to file for hot dogs? Are you planning to expand into related areas like, let's say, potato chips or buns? Are you going to offer catering services? Because that's a separate category. So those are the discussions you have to sit down and have with your client as a trademark lawyer and help guide them. And the other one is maybe the words Robert Hammer hot dogs and lemonade is not a very strong mark. So the other advantage that a trademark lawyer can help with is advising their client on the strength of their mark, even if they're able to obtain it, and do a knockout search to determine if the words Robert Hammer hot dog and lemonades is already out there in use or would potentially cause a likelihood of confusion issue, which is essentially more problems down the line, right? Yeah. An ounce of prevention can help with, whatever. And lawyers can, sorry for messing up the cliche, but in my mind, preventative medicine, whether you're doing yoga or Tai Chi, is going to help you save on medical bills down the road. And the same thing works with trademark law or any kind of company that's looking to, whether should they spend this money on lawyers up front? Well, if you don't want to deal with a potential lawsuit down the road that's going to cost on the order of 10x to 100x more than dealing with it on the front end, then yeah, it's worth it.
Well, and I've also seen it in a very related vein, which is if you're going to sell your company, you're going to buy a company, what does the status of the trademark and intellectual property protections do to the purchase price, right? We've had scenarios where, seller comes to us and they want to sell the company, and there's a lot of intellectual property associated with it, but it wasn't registered. It was just out there. They were just using it, and that has a negative impact on the price that they can get, because the new buyer has to go through and do those protections, and B, runs the risk that their protections have been eroded because it wasn't done 5, 6, 7 years ago. So those are all areas where we see some practical effects to it. We did have a question pop up in the chat, which really gets into my next question, and you kind of alluded to it at the beginning, but what are some of the benefits to trademarking? Is there a reason to trademark? And to tie in the question from the chat, is there a difference or a reason that a nonprofit may want to look at trademarking its logo versus a for-profit? Any distinctions in that area? And I know I threw a lot of questions all at you at once, so I'll give you a little time to go through that.
Well, I guess the easiest answer is yes, there's a lot of reasons to pursue trademark registration. And the biggest one is that it gives you the exclusive right to that name or logo. The question becomes so put it this way, if resources were a non-issue, so if everybody was gifted an unlimited supply of money to use for their legal fees, then everybody should be pursuing trademarks early and often. And if you look at what the big companies that do have unlimited resources to some extent, like a Google or Coca-Cola or Clorox, any company that's in the Fortune 500 or Fortune 50, they're all filing tons of trademarks. We could do a search live on any of those names and you'll find a giant list, which is evidence that it's very valuable and important to them to have that asset, even if they don't enforce it. For example, I had a client that was, their trademark was opposed by Apple Inc. over the logo of the Apple itself. And Apple didn't want money from our clients. They didn't want to sue our clients, but they were aggressively taking the strategy that we want to put any questions to bed that anyone out there can use an Apple that even sniffs at the similarity of our Apple logo. And the fact is, they're big enough and strong enough to outspend our client, who at that point basically had to make the prudent decision, business decision, to revise their logo and look. So a big advantage of getting a registration is, to some extent, confirmation from the federal government that you own this mark and that it's free and clear from confusingly similar marks. And so it's on the other side to prove that it does not qualify for the bag of goodies that come with a federal registration and that bag of rights. So that's an advantage. In addition, if the nonprofit plans to expand, so if it's a local food bank and they have no intention of expanding into Ohio or other states and so on, maybe there's no reason to spend the $1,000 to pursue a trademark registration. Even though I do have to say, the U.S. Patent and Trademark Office has a program where they've licensed certain universities around the country to practice trademark law for free for qualifying nonprofit organizations. So if it's a nonprofit that doesn't have the money to hire an effective lawyer, I'm not guaranteeing you the quality of the services, but these clinics at these law schools like Detroit Mercy has one, Michigan State University, I think, used to have one. And they will, if you qualify and you get in their list or on their backlog, you might be able to access affordable free services. And then there's pro bono programs for this too. But essentially, a trademark has to show actual use and in commerce, and they have to submit a statement of use. So how are you using the mark, with a photograph, etc. The other benefit for the nonprofits is that it's an indirect benefit, is that let's say we obtain the name Robert Hammer Nonprofit, right? Helping with hungry kids. And you file for a trademark registration for that name. The next person that wants to use the word Robert Hammer for hungry kids, or any combination of those, Hammer for hungry kids, your name will come up in their search when they're trying to do a clearance search. they're going to have to pause and rethink what they're going to do because you're out there. And the last thing you want to do is end up in a situation where you're conflicting. Probably one of the more famous trademark conflicts, which I'm aware of because I'm of that generation that loved to watch WWF as a kid, circa 4th, 5th, 6th grade. WWF is now
a little bit here.
Right. WWF sounds like WWE is now WWE, which is a World Wrestling. And at one point they got in a trademark conflict with the nonprofit WWF, which is the World Wildlife Foundation. Okay. Now, I don't remember the facts or why they ended up having to be the one to change their names. They're also in completely different categories, right? One is entertainment, world wrestling, whether you are entertained by that or not. And the other one is wildlife preservation society. So there's a benefit there in that they were able to restrict the dilution or tarnishment of their mark by getting the wrestling group to change their name and change their logo. And look, in the end, picking a good name, picking a good logo can be valuable, but the goodwill that you establish for your mark matters so much more.
Yeah.
Right. Well, WWE changed their name and they still are booming in billions of dollars. Yeah. So that industry didn't go away just because they changed their name. And so people should be less fearful of that. Another example is ESPN, which I'm a big fan of because I'm a huge sports fan. But ESPN's a terrible trademark, and they established that as like Eastern Sports something network, and that was in 1980, and now it's a household name, that acronym ESPN. So the goodwill you obtain through producing high quality products and services is going to dominate more than the name, but the name is valuable.
Yeah. Well, and it's really funny because the trademark case that I always remembered, it became a kind of a little bit of a household joke, or maybe just an industry joke, was the microbrewery that was using the Frappuccino name. They got a 17-page cease and desist letter from Starbucks, and they sent them a check for $6 and stopped using the name, representing their profits from the sale. I mean, again,
right.
microbrewery didn't go under, but they had to stop using it. So
the thing is that the big companies like Starbucks and Apple, like I just told you about,
yeah,
they for the most part want to be good citizens. They're not in the they're in the game of managing their business and selling their products. Yeah. They're not interested in suing little guys and shutting them down. What they do want more than anything else is to make sure nobody is using brands similar to theirs, so they protect it. Because if they let that happen, it's a little bit of a slippery slope. That if they don't go after everybody and they let some people slide, then all of a sudden it's an argument that like, well, you let these guys slide, so this obviously exists without causing confusion.
Yep.
Yeah. And they're aggressive about that because they have the money to be aggressive about it.
Got it. Well, yeah. and that kind of segues into my last question, which is, what is the time frame to get a trademark done, and then what kind of protections does it offer you? You talked a little bit about cease and desists and things like that. So I'd like to have just a little bit of an understanding about, again, the timeline, and then once you do have your trademark, what the options are to enforce it moving forward.
So I didn't fully answer one of your questions before, and this is relevant here. When you apply for the trademark, you not only need to have what are we filing for? The word, the design, etc. And then in addition to that, you have to submit a specimen of use. And what's a specimen of use? So let's say I sell these headphones, and on the side of these headphones is the trademark Aftershocks. Okay, it's their logo, it's their word. So if you're selling a good, we have to provide a photograph or some sort of evidence that the mark travels with the product, the good itself. So if I have a client that's a chemical company, they sell plastic pellets in giant barrels. I need to see the trademark they want to use on the packaging or the barrels of the product. For Aftershocks, for example, they mark their product, they put the mark right there on the product itself. Big Mac, you don't want the word Big Mac on your bun unless maybe you're quirky that way, but they put it on the package of the sandwich.
Yeah.
Right. So it has to be on the package or the good itself. And you'll notice, if you start being aware of that, you'll start noticing that everywhere, right? Everybody that sells anything is putting the name right there on the product. And so those of us that wear Adidas shirts or Nike shirts or hats, say Titleist and Callaway on them, those we're just advertising for those companies, and that's a way of their showing use. For services, then it gets a little easier where you can show websites and information on the content. But sometimes people say like, oh, I sell this stuff and here's my marketing materials. Well, marketing materials don't automatically qualify as specimens. You have to show it. You have to show how the mark travels with the goods themselves for goods, and for services, it's a little less restrictive. Okay. So that's part of the process of filing. And then the time frame from the moment we file to the moment that you get a registration, assuming there's no problems, meaning there's no confusingly similar refusals or a refusal for being merely descriptive, which is an example of something that's considered a weak mark. That process, again, assuming no issues, we don't know back and forth with the trademark office, should take anywhere from 6 months to a year. Sometimes it goes longer and sometimes it goes shorter. It honestly depends on the backlog that the trademark office has and which trademark examiner is handed your application.
Okay. And then once you get that trademark, what are your rights to enforce it? Can you stop people from using it? Can you sue for damages?
That's a great question. There's no trademark police. So to obtain a trademark registration, it has tons of benefits. Yeah. One of them is the most obvious one is the ability to exclude others, right? Exclusive right means the right to exclude, and that's what the one thing intellectual property has in common. I write a song, I can exclude everybody else from using it, right? Or playing it on the radio. If I invent something, I can exclude everybody else from using my invention for a limited time. If I have a trademark registration, I can exclude everybody else from using it. One of the ways I can use that permission power, that right, is by giving somebody a license. So take a university like University of Michigan or Michigan State University in our neck of the woods. Those companies have a licensing division and they license their branding and their names out to Nike, Champion, Reebok, Under Armour, etc. Because the one thing these universities don't do is have a manufacturing facility that's pumping out hats and t-shirts and sweatshirts, etc. Yeah. But they make tons of money off their licensing, and that's why we know college sports is a big deal, because the difference between Michigan or Michigan State making a college playoff bowl and making some no-name bowl or not making a bowl at all can be anywhere on the scope of like $1 to $3 million.
Oh, wow.
Revenue for the university because of this licensing factor that they get to sell all this extra stuff in order to be a part of that, especially for like the years that they make it to the playoffs and so on. So that's one advantage, that you can now license your mark if you need to. From a direct like business standpoint, you come up in searches. So now it's a defensive tactic, right? Now you not only do you have a federal registration, you're preventing your potential competitors from using a name that's similar or confusingly similar to your mark. It's also an asset of the organization, that the organization now increased their overall value of the company because they own this intellectual property. Okay, so those are some of the advantages. A further advantage is I don't have to establish common law rights, right? I have a presumption of validity when I do send a cease and desist. We talked about like, I can use this name for 15 years without registering it. Well, the problem with suing somebody is that the burden's on me to prove that I own this right and can exclude others. A federal registration is a presumption of ownership of those rights. Yeah. And then after the 5-6 year renewal mark point of view, like after you register, between the 5th and 6th year, you can obtain what they call incontestability status, which from a legal standpoint, eliminates defenses that the other side can use in an infringement case against you. For example, they can't claim that your mark is too descriptive. That defense is eliminated. So now you have even stronger rights once you reach that level.
So much like filing, a financing statement, you're putting the world on notice.
Yeah, you're satisfying the notice requirement. Yep.
You got it. Yep.
Yeah, and that's one of the benefits of copyright registration too, is that you have the right, now you have the right to sue and ask for special damages for copyright infringement versus just having that common law copyright in the work of authorship that you captured in a tangible medium, right? I write a song, but I don't file the registration, or I draw a picture and I don't file the registration. and all of a sudden I want to sue somebody, I have to now file for the registration to obtain it, and their behavior prior to that filing is not subject to damages.
Yeah. Okay.
So,
well, Mike, that is all the time that we have for today. I know we didn't get to all the questions in the chat. I will encourage anyone to reach out to Mike who didn't have any questions answered there. With trademark and intellectual property, we could spend weeks or months talking about this. We're only scratching the surface here. But I definitely want to
thank class on the subject.
Yeah, exactly. I definitely want to thank you for taking the time to kind of give us the overview of trademarks, and I'm sure we're going to have you back again to discuss some of the other areas of intellectual property protection, like patents and copyrights and things like that. Because again, they're just areas that you need to know when you need to reach out to someone, right? That's the reality of this. There's a lot of good information out there. There's a lot of bad information out there. What we need to do is make sure we know and teach people when they need to pick up the phone and say, hey, you know what, we got an issue. Let's figure out what we need to do to best protect the organization ourselves based on what we're planning on currently doing, what we're planning on doing in the future. So
I just want to say that, Rob, the one thing that is important to know is that when you have a trademark registration, now you can use that famous R with a circle. And those of you that today, when you go out into the world and you see other marks, keep an eye on which ones have the R circle and which ones don't. And that gives you an idea that that satisfies that notice requirement. And without that registration, you can't use that R circle. And that's a real nice advantage. That's another benefit of getting a trademark registration.
Awesome. Awesome. Well, that'll be an hour. But I want that this was recorded. We will be sending it out to everyone who's registered. If you do have any questions or you want to watch it again, if you want to get a little bit more information on Mike's position as to the Coke versus Pepsi argument, I'm glad he didn't get into American versus Lafayette Coney Island, because we would have lost half the people here. And we really want to thank you for your time. And reminder, we are going to have another session next month on October 11th. Please be on the lookout for some additional information and the topic, which should be coming out from Foster Swift. Again, I want to thank everyone for your time. Mike, I want to thank you for your time especially, and I hope everyone has a fantastic week. And as always, if there's anything that we can do, please feel free to reach out to discuss. Thank you so much.
And our contact information is in the chat available.
Correct. Yep. Absolutely. And again, all that information should hopefully be going out via email to everyone that was on this session.
Thanks for having me, Rob. Thanks for everyone for tuning in.
Thank you, everyone. Take care. Have a great day.